Welcome to Deconstructing the Law, where we will discuss legal concepts and issues in general, and those that affect the construction industry in particular. In this and the next few episodes of Deconstructing the Law, we will discuss risk allocation tactics, or RATs, how to spot them in your contracts, what they may mean to you, and how to deal with them. Before we proceed, it's important to note that this discussion uses examples interpreting Maryland law. The law in your jurisdiction may be different and varies from state to state. As the construction industry begins to come out of its doldrums and projects begin to get off the ground, more and more clients have been calling with questions about the contracts they've been receiving. It seems that construction contracts now contain lots more language addressing project risk. Owners and general contractors are looking to transfer project risks to downstream subs. The trend is understandable given the economic climate. Owners want to make sure that their projects can be completed as close to budget as possible, and general contractors want to make sure that they don't get sandwiched between the owner and a subcontractor. So everyone plays hot potato with risk. The most common RATs are the pay when paid clause, the pay if paid clause, indemnification provisions, lien and claim waiver provisions, liquidated damages provisions, and provisions limiting damages that can be recovered. Let's talk about the first two RATs, the pay when paid clause and the pay if paid clause. These RATs are used by general contractors to transfer the risk of owner non-payment to subs and suppliers. The pay if paid clause provides that the general contractor is only obligated to pay subs and suppliers when the general contractor gets paid by the owner. If the owner does not pay the general contractor is under no obligation whatsoever to pay the subs and suppliers. If you're a sub or supplier, the pay if paid clause is an obvious problem because it means that you may not get paid. It's also a problem because as a sub or supplier, your ability to evaluate the owner's creditworthiness is very limited. When an owner approaches a contractor to build a project, the contractor has an opportunity, and more importantly the leverage, to become comfortable with the owner's financing and creditworthiness. The contractor can demand copies of financing documents, get assurances from the bank regarding financing, and obtain the information it needs to make an informed decision about whether or not the owner will pay for the work. Subs and suppliers, on the other hand, do not deal directly with the owner, so they cannot get the same information from the owner as the contractor can get. Oftentimes, subs and suppliers do not have a clear idea who the owner is. They have to hope that the contractor did his homework so they don't get stiffed. Nevertheless, the pay if paid clause seeks to shift the risk of the owner's creditworthiness to subs and suppliers, who have very limited means available to evaluate that risk. Because the pay if paid clause can have an unjust result, Maryland courts have held that the pay if paid clauses are only enforceable if they contain certain magic language in them. The pay if paid clause must contain specific language making the owner's payment to the general contractor a condition precedent to the contractor's obligation to pay the subs and suppliers. If the pay if paid clause does not contain this magic condition precedent language, the clause will be converted into a pay when paid clause. A pay when paid clause is very similar to the pay if paid clause with one important difference. It only transfers the risk of owner non-payment to subs and suppliers for a reasonable period of time. In other words, the general contractor does not have to pay the subs and suppliers unless the owner pays the general contractor, but the general contractor's underlying obligation remains in force. If the owner does not pay the general contractor in a reasonable time, the general contractor will have to pay the subs and suppliers regardless of whether the owner paid the general contractor. A couple of practice pointers. Analyze the pay if paid clause to see if it has magic condition precedent language. If so, during contract negotiations, try and eliminate the pay if paid clause, or at the very least, convert it into a pay when paid clause. If converting the pay if paid clause to a pay when paid clause is not an option, try to obtain as much information regarding the owner's financing so that you can make an informed decision about whether or not to take the job. If you have any questions, please give me a call at 410-842-0142 or email me at erobbins, that's E-R-O-B-B-I-N-S, @harrisonlawgroup.com. Thanks for watching Deconstructing the Law.